matter of Office of the Prosecutor and Jeffrey Baratheon, the Special Court of the Republic of Westeros is now in session. Please be seated.
Yes, good morning. I'll take the appearances first.
Your Excellencies, may it please the Court, my name is Sheldrake, initial R, Senior Counsel for the Prosecution, in the matter of the Office of the Prosecutor against General Jeffrey Baratheon.
Thank
I'm
you, Mr.
joined.
Chairman. Yes.
I will be speaking for 15 minutes. I'm joined by my learned Junior Counsel, McAndrews, initial L, who will also be speaking for 15 minutes. May it please the Court.
Thank you. Yes, for the defence, please.
May it please the Court, Your Excellencies, my name is Najaran, and I appear before this Court with my learned co-counsel, Miss Best, as counsel for the defendant, Jeffrey Baratheon. We each reserve 15 minutes speaking time. May it please the Court.
Thank you. Yes, Mr. Sheldon.
Your Excellencies, this is a case about whether the leader of an extremist group should be given the luxury of turning a blind eye to the crimes committed under his command. We, the prosecution, submit that there are three things that must be established in order to successfully prosecute General Jeffrey Baratheon. These are that this court holds jurisdiction to consider this case, that war crimes did in fact occur, and that General Jeffrey Baratheon is responsible for these crimes. I will be dealing with matters relating to jurisdiction, and then for the following two matters in relation to count one. My learned Junior Counsel will then deal with the existence of war crimes and responsibility for them in relation to count two. Your Excellencies, we submit in relation to jurisdiction that this court was legally created within the Chapter 7 power of the United Nations Security Council. Therefore, its statute is binding, and its jurisdiction will be informed from that statute. Under Article 1 of the statute, the court has a jurisdiction to consider crimes against humanity and war crimes. We note that only war crimes are alleged in this case, and it is only the existence of war crimes and the existence of an armed conflict within which these war crimes have taken place that the defence has raised issue to with respect to jurisdiction. Thus, this will be the thrust of my jurisdictional arguments. In relation to the existence of an armed conflict, the prosecution submits, firstly, that there was a non-international armed conflict beginning on the 30th of March 2014 and ending on the 15th of January the 12th of January 2015. We submit that there was an organised group, Lannister State, which engaged in armed activities against a state, the Republic of Westeros. This is a non-international armed conflict. Factors that will determine whether it is a non-international armed conflict, as distinguished from acts of terrorism or banditry, are the severity, the protracted nature, and the organised nature of Lannister State. We submit that as it had a hierarchical command structure and was unified under General Jeffrey Baratheon, it was an organised group. We submit that as the conflict lasted for a period of greater than 9 months, it was a protracted conflict. And we submit that as there were cities and towns taken and captured, that there were aerial bombings, and that the numbers of the forces on Lannister State side exceeded 50,000 men, and on the Westerosi side reached at least 20,000 men in the city of Dorne alone. We therefore submit that this is clearly not acts of crimes or banditry or terrorism and is a non-international armed conflict.
Counsel, if I may stop you there, you made a submission about the nature of the armed conflict. Does anything turn on that? If, for example, this was an armed conflict of a different character, would your submissions be different?
Our submissions will be materially the same, Your Excellency. In fact, we submit in the alternative, should this court hold that the conflict is not sufficiently protracted, severe, or the groups are not sufficiently organised, that Lannister State had in fact formed a state and is therefore an international armed conflict. To that end, we submit that Lannister State had achieved the requirements of statehood under the Montevideo Convention, these being that it had government. We submit that the existence of a presidential decree, paragraph 36 of the facts, demonstrated they did in fact have government. A clearly defined territory. We note that this requires only some clearly defined territory, and while the borders are not defined, the cities of Dorne, Sunspear and Old Town at various times did fall within Lancaster State control and Lancaster State territory. And finally, a requirement for a permanent population, of which once again there is some permanent population. And finally, the capacity to enter into international relations. We submit that the recognition by the Republic of the Iron Islands and also the actual entering into of international relations with the Republic of the Iron Islands on the 13th of February was sufficient to attract statehood for Lancaster State, and therefore it is an international armed conflict.
And if there's no armed conflict at all, does that mean that there can be no indictments and convictions under this court?
That means, Your Excellency, that there may be no indictments or convictions under the counts brought within this charge, as these charges relate only to war crimes, and war crimes must be in the context of an armed conflict.
Thank you.
In relation then to the existence of war crimes, we submit that from April 2014, women and girls were held within a house in Dawn, as well as in other areas around Dawn, Sunspear and Old Town, for the purpose of rape, sexual slavery and enforced prostitution. We submit that this constitutes a war crime under Article 5 2A Roman 3 of the statute of this court, in accordance with Count 1 of the indictment against General Jeffrey Baratheon. There are 46 women and girls who escaped from Lancaster State captivity. Around half of these gave statements to Amnesty International regarding their captivity, and around 9 of these testified to the existence of the Dornish house, the house around Dawn and Sunspear, which is alleged within this count. We therefore submit that there is sufficient evidence that beyond reasonable doubt war crimes were committed by Lancaster State forces. There is also sufficient nexus between the commission of these crimes and the context of the armed conflict itself.
Could I just, counsel, pardon me, just draw you to Article 5.1 of the statute of this court? Could you just comment very briefly on, in particular when committed as part of the plan or policy of large-scale commission of such crimes, how does that relate to the allegations that are being made about the alleged sexual slavery?
Yes, Your Excellency. We submit that this is not a strict requirement, that it being part of a systematic attack is not a strict requirement for this court to hold jurisdiction.
But what are the words in particular then mean? They must mean something, sure.
We submit that they are merely indicative of the types of crimes that this court seeks to deal with. However, they are not an exhaustive requirement to which the court will only hold jurisdiction where there are systematic attacks.
So you're saying this is not, there's no submission that this is part of a plan or policy or part of some large-scale commission. Is that your submission? That essentially does not exist in this?
To the contrary, Your Excellency, we do submit that in any event, these attacks were conducted in a systematic way and in the context of a systematic attack and discrimination against the Dornish and Andal people. We note that Lancaster State was formed on the basis of discrimination against Andals and Dornish, and in particular against Andal rule, and that all of the attacks conducted by Lancaster State, both military and non-military, have been against Andals and Dornish, as has all of the sexual slavery and rapes and enforced prostitution alleged within this count. Therefore, we submit that a war crime has been committed by Lancaster State forces, and we move to command responsibility and the particular responsibility of General Jeffrey Baratheon. We acknowledge that there is insufficient evidence in this case to prove individual criminal responsibility for Jeffrey Baratheon with relation to this particular count, as General Jeffrey Baratheon cannot be proved to have taken any forward or positive action towards the commission of the crimes. However, we may prove on these facts that General Jeffrey Baratheon had command and superior responsibility under Article 8A of the Special Statute of the Court. We seek to break up his command responsibility into 3 distinct time periods, as shown in the timeline provided to both the judgment panel and to the defence. These time periods that we will be dealing with are firstly the dates from the 15th of October to the 28th of the 15th of October to the 28th of October. Secondly, from the 31st of October till the 30th of November. And finally, we will go back and deal with April through till the 15th of October, as there are different degrees of evidence available for these three distinct time periods. In relation to the first time period, the 15th of October to the 28th, we submit that during this time, and in fact during all times, General Jeffrey Baratheon had effective command and control, which is the first element contained in Article 8. The test for effective command and control is whether or not he had the material ability to prevent or punish the perpetrators of the crimes. We submit that his de jure position as a military commander is evidence and establishes a prima facie presumption that he was in fact in effective command and control, as was held by the ICTY in the Delalovich case. We therefore submit that there is a presumption that General Jeffrey Baratheon is in command and control that the defence may not rebut. Further to that point, it is demonstrated on the facts.
Could I just stop you there? You said prima facie. This demonstrates that he's got effective control. That raises a presumption that the defence cannot rebut. Surely it's for you to demonstrate beyond reasonable doubt rather than for the defence to rebut something. Isn't that the case?
We accept that the prosecution must discharge this burden beyond reasonable doubt. However, as was held in the Delalovich case, there is a prima facie presumption in a position of de jure military command that there is effective command and control.
But that wouldn't lead to a criminal conviction, surely not. There may be circumstances about the ability of the individual to carry out those functions. So it's for you, is it not, to demonstrate your case rather than for the defence to rebut a prima facie presumption? Is that not the case?
That is correct, Your Excellency. However, there is significantly more evidence than merely his de jure position as a military commander. I draw Your Excellency's attention to General Jeffrey Baratheon's statement regarding Commander Bolton, saying that he tasked Commander Bolton with ensuring the values and freedoms of the people. This indicates that he is capable of giving orders. I also direct Your Excellency's attention to paragraph 36 of the facts, where at the 29th of October, he called a meeting for his senior military commanders, meaning that he could order his senior military commanders, and also released a presidential decree giving standing orders to all Lannister state soldiers. This means that he is in effective command and control of Lannister state forces. He is the general at the top of the chain of command, and the fact that his command and control may have been indirect is not fatal to the prosecution's case that he was in effective command and control, as was held in the Bremer case.
Sorry, could I just ask you whether it could also be viewed that he issued the presidential decree requesting that they comply with the rules of IHL, and yet prior to that, subordinate Bolton had been encouraging troops to commit rape and pillage anyway. So it could be counted perhaps, and I'd like to hear your views on this, as to whether Bolton was actually exercising authority and effective control, and that the fact that the rape and pillage occurred was more suggestive that General Baratheon did not have the control over his subordinates.
I understand your concern, Your Excellency. However, we submit that concurrent command and control is still effective command and control, as was held in the Bremer case. If it can be held, which it can, that General Jeffrey Baratheon had effective command and control over Commander Bolton, then he also had effective command and control to the extent that Commander Bolton did as well. The mere fact that he was not exercising his command and control over Commander Bolton does not mean he did not have effective command and control through Commander Bolton to the forces on the ground. We therefore submit that he was in fact in effective command and control of Lannister state forces.
Could it be argued, Counsel, that even if one disagrees with your submission just then, do you take any store by the fact that the accused seemed to congratulate his subordinate for various activities. Can one essentially be guilty as a commander ex post facto by accepting and acknowledging and condoning it?
We submit that a commander may be guilty after the fact as a result of a failure to punish or prosecute, and that goes to that particular factual scenario, that he failed to punish or prosecute Commander Bolton and the forces on the ground for their war crimes in relation to the house outside of Sunspear in which these rapes and sexual assaults were occurring. I will briefly summarise my remaining points in relation to command responsibility. We submit that he had actual or constructive knowledge between the 15th of October and the 28th of October. This actual or constructive knowledge we submit comes from the Essos Times article published on the 15th of October, the front page of which declared a humanitarian emergency within Westeros. We note that at submission 7 of the defence's written submissions, they acknowledge that immediately following this, I note that my time has elapsed. May I request a brief extension to summarise my remaining points?
How long do you seek, Mr. Sheldon?
2 minutes, Your Excellency.
You should have that time.
Thank you, Your Excellency. In relation to command and control at this time, we submit that the calling of the meeting, according to the defence, immediately followed. According to the facts, it says at paragraph 36 where he called the meeting following the publication of the Essos Times article. And as there was no media published in the interim time that is on the facts, we submit that the latest he could possibly have known that there was a humanitarian emergency was on the 15th of October. We submit that actual or constructive knowledge is either actual knowledge, which we do not submit, or constructive knowledge, which is a receipt of a specific piece of information alarming enough to put him on a course of further inquiry that would lead him to the commission of the crimes, as was held to be the test in the Strugar case. We therefore submit that the declaration of a humanitarian emergency was sufficient to put him on notice that there were humanitarian crimes occurring within that area. We therefore submit that he should have taken some action in the 16 days between the 15th of October and the 31st of October. There are no measures taken during this time. It is inconceivable that a general who is able to appear on television is unable to contact his commanders within a matter of 24 hours, let alone 6 days, and be able to issue cease and desist orders and standing orders to his officers to investigate, prosecute, report, and punish any actions, any illegal actions taken against civilians by Lannister state forces. The failure to do so alone constitutes a war crime, as it allowed these war crimes to continue for these 16 days. This also addresses the final requirement, which is the failure to take reasonable measures. As I previously stated, no reasonable measures were taken in this time. For the remainder of my submissions, I defer to my written arguments, and that concludes my particular oral submissions. I defer to my learned junior counsel.
Your Excellencies, I'll be speaking to the second count on the indictment against General Jeffrey Baratheon on behalf of the Office of the Prosecutor, and that is that Lannister State Forces violated Article 5(2)(a) Roman 2 of the Statute of this Court by intentionally launching attacks in the knowledge that they would cause casualties to civilians which were clearly excessive in relation to the direct and concrete military advantage obtained by Lannister State, and that Jeffrey Baratheon is criminally responsible for the actions of the Lannister State Forces in this regard. I'll firstly be dealing with the establishment of the crimes by Lannister State Forces on the ground, and I will then turn to the question of General Baratheon's command responsibility for these actions as provided for under Article 8A of the Statute of this Special Court. Your Excellencies, we submit that the actions of Lannister State Forces in bombing the Old Town agricultural sites and dam, and then preventing relief supplies reaching civilian populations in Old Town through the implementation of checkpoints and their subsequent looting of an ICRC convoy are war crimes. I'll be dealing first with the bombing of the dam and agricultural sites, and I will then turn to the denial of the relief supplies reaching the civilian population. At the outset of my submissions regarding the bombing of the dam, I would like to firstly address point 8 of the defence's written submissions regarding these attacks. The defence has stated that it cannot be said that the attack could only have been intended to cause civilian casualties. However, the prosecution does not submit the intent of the attack is relevant to the commission of the crime. We submit that it is the incidental effects of the attack which make the acts illegal and come within the ambit of Article 5.2a, Roman 2 of the statute of this court.
But there is clearly an intent requirement for the crime. You're not saying that there's no intent requirement. So what is the intent requirement here?
The intent is that the attacks were launched intentionally by the forces. We accept that they may have been launched in the cases of the dam and agricultural sites, launched against legitimate targets. However, it is the incidental effects that we submit were clearly likely to result from these attacks on the civilian populations, which renders them illegal.
But is the test clearly likely to result? Don't the words say in the knowledge that they will cause? Doesn't that represent a certainty rather than a likelihood?
Your Excellency, we submit that the test is as was found by the ICTY in Gallup, the Gallup judgment at paragraph 58.
Is there a relevant provision in the ICTY statute that has that wording in there?
Yes, Your Excellency. We submit that the test is that a reasonably well-informed person in the circumstances could have expected excessive civilian casualties to result from the attack, and we submit this is made out in this case. The first question for the court in relation to whether these attacks were excessive is to assess the military advantage which was sought to be obtained. Now, we note the submissions of the defence at paragraphs 9 and 10 of their written memoranda that the military advantage to be obtained from these attacks was the taking of Old Town, and we accept that the taking of Old Town in and of itself is a legitimate military purpose. However, the taking of Old Town, which occurs at paragraph 26 of the facts, did not occur until the 1st of July 2014. The attacks, which we submit are illegal, occurred in May 2014. Now, we submit that this means that the military advantage could not be direct and concrete. At best, the contribution of the attacks which damaged the dam and the agricultural sites could at best be said to have had an indirect, consequential assistance to the overall campaign. However, we submit that in order to be a legal purpose for the question of the effects of these attacks, that military advantage would have needed to be obtained quite immediately by the Lannister State forces in carrying out these bombing campaigns in the vicinity of the dam and the agricultural sites.
And pardon me, Council, the particular provision upon which you rely upon actually does use the word overall, doesn't it? It says there's a balancing act with the overall military advantage anticipated, which suggests not necessarily in relation to just one specific act, but much broader. So doesn't that run counter to your submission which you just presented?
We acknowledge that an attack may have an advantage in it should be viewed in the broader context of the ongoing fighting. However, that attack must still obtain an advantage at that time in that broader context, which is direct and concrete.
But that's a much more difficult thing to prove, isn't it? That you're saying if there's no advantage from this particular attack, then there's no advantage in the broader overall scheme of things. But that one doesn't necessarily follow from the other. This seems to suggest that you need to look at a much broader range, and therefore that gives perhaps more scope to military people to say that there is a military advantage that's appropriate. How do you respond to that?
We acknowledge that it should be looked at in that broader scope. However, looking at it in that broader scope does not neglect the fact that it has to be a direct advantage at the time. And we submit that the passing of at least 1 month between the attacks, assuming they were launched at the very end of May, negates the any possibility that they also would comply with the direct requirement, and that even if it was an advantage in the overall context, it fails the element of under the article of being direct, and that we submit that the attacks must comply with all being direct, concrete, and within the overall at once. We submit that the fact that the dam supplied 60% of fresh water to the city of Old Town, and the fact that at paragraph 35 we know that widespread civilian deaths occurred from lack of food, demonstrates that a reasonably well-informed person in the position of Lannister State Forces would have expected excessive civilian casualties to have occurred from the carrying out of bombings around the dam and the agricultural sites. For this reason, we submit that the actions are violations of Article 5.2a, Roman 2 of the Statute of this Court. I will then turn to the issue of the checkpoints. We submit that the checkpoints...
I'm sorry, Councillor, can I just on that point, you mentioned excessive. The wording is clearly excessive. So can you explain to this Court the difference between something that is excessive and something that is clearly excessive, and explain why in this case you've satisfied that second requirement?
We accept that the test of being clearly excessive does set a higher standard than being excessive.
Because excessive was the term you used. That's not enough by your own submission, so please explain.
I would retract that in that case, Your Excellency, and submit that the attacks were launched in the knowledge that the civilian casualties would be clearly excessive. And we submit that this would leave no room for ambiguity in the position of the attacker. We submit that in the light of the fact that the dam supplied over half the freshwater supply for the town, and the fact that the agricultural sites provided a food source for the civilian population of the town, and as I have earlier submitted, without a direct military advantage for the attacks being conducted in the vicinity of these sites, meant that there was no ambiguity, that the civilian casualties that would eventuate from such actions would be clearly excessive in light of being no direct military advantage in that case. In regards to the checkpoints, we submit that the implementation of checkpoints is an attack. We note that attack is defined under international humanitarian law as an act of violence against the adversary. We note that the adversary in international humanitarian law is not limited to the opposing military force, as found in prohibitions on attacks on certain protected persons and civilians, and we submit that the denial of Red Cross supplies and civilians does count as the adversary. And in terms of an act of violence, we submit that the imposition of checkpoints by a military force is a threat of violence, which resulted in the compliance with the checkpoints by the civilian population. And this does not owe to any other civil authority that the forces would have held.
And how does that mould with the idea of launching an attack? You're saying now it's a threat of violence. How does that equate to intentionally launching an attack, which you said is the mens rea requirement?
We submit that launching means is equivalent to carrying out.
And what's the basis for that submission?
I have no specific authority.
Before you're submitting for the first time to an international court that launching means carrying out something.
Yes.
So can one launch an attack by omission?
No, we do not submit. And we do not submit that there has been an omission on the part of Lannister State Forces on the ground in this case. We submit that it is active action of setting up the checkpoints and preventing military medical supplies reaching civilian population, which has occurred here. And we submit that it's the threat of this violence, which is the act of violence. And we would draw an analogy to Article 2.4 of the UN Charter, which we acknowledge is distinct, where the threat of use of force is equivalent to the act of actually using force. And we submit that an act of violence includes the threat to use violence. And we also submit that the looting of the ICRC convoy in any event is an active step of violence which prevented medical supplies reaching the civilian population, which we know at paragraph 30 of the facts caused 1,000 civilian deaths. We note that the action of Lancaster State Forces, as found in paragraph 24 and reported by the World Health Organization, was to specifically design the checkpoints to deny civilians access to medical care. And we submit this act makes the civilian casualties clearly disproportionate in relation to any military advantage obtained from the actions. Your Excellencies, I'll then turn to General Jeffrey Baratheon's command responsibility for these actions, and we submit that he is responsible under Article 8A of the statute of this court. We submit that General Jeffrey Baratheon is a military commander in effective command and control of Lancaster State Force at these times, and on those 2 points, I defer to the submissions of my learned senior counsel in relation to this time period. The next requirement, Your Excellencies, is found in Roman 1 of Article 8A, and that is the mens rea requirement that Jeffrey Baratheon knew, or owing to the circumstances at the time, should have known that the forces were committing or about to commit such crimes.
Is that a mens rea requirement, really? Do you really mean that, or is that just a question of statement of knowledge? Is a mens rea requirement of command responsibility that you know something is going to happen? Anyway, I seek your submission.
We submit that he knew it was going to happen and then cumulatively failed to act. His act or admission in light of the knowledge that this was these illegal actions were carrying out.
But is there a difference, for example, in the Rome Statute, the International Criminal Court, obviously we're not bound by that, Article 30 distinguishes between knowledge and intention. So I'm just seeking clarification from you as to whether you are concentrating the two concepts together, or do you say that knowing or ought to know equates to the mens rea requirement? Perhaps you could move on if you like, but I just raised that for you.
We do not submit that there needs to be active intention to commit an illegal act. It is, in this sense, the responsibility under criminal law is imputed on Jeffrey Baratheon by virtue of his position, and it is not relevant, we submit, whether he sought to commit an illegal act or did not have any intention, but it is his responsibility as a commander under international law, which means that he should have taken action. So we do not seek to merge the two concepts together. We submit that Jeffrey Baratheon had actual knowledge of the attacks on the damned agricultural sites by virtue of the fact that he was at the apex of the Lancaster State chain of command, and these actions in the bombing were part of a major military campaign and towards major sites which were the city of Old Town, and that this actual knowledge may be inferred circumstantially, as was held by the ICTY de Lalich at paragraph 386. In regards to the checkpoints, we submit that General Jeffrey Baratheon had constructive knowledge, and this test is set down by the appeals chamber of the ICTY in Stuttgart, paragraph 304, where the chamber stated that the superior must be in receipt of information which is sufficiently, I note my time has expired, may I have a brief 2 minutes time extension to sum up.
Yes, you may. Okay.
Thank you. Thank you, Your Excellency. And the test is that the superior was in receipt of sufficiently alarming information to put them on notice of the risk that crimes might be committed and by the subordinates and justify further inquiry. At paragraph 23 of the facts, General Baratheon attends a meeting in which the second in command of Lancaster State Forces, Commander Bolton, says we need the checkpoints, we must starve them. Now, we submit that it is unacceptable under international criminal law for the person at the apex of a chain of command, no matter what the rest of the discussions at that meeting were, to, without further inquiry into how these checkpoints would be implemented onto the ground, after hearing such an overt intention to commit manifestly illegal acts towards protected persons, that it is unacceptable for him to have merely put his hand in the eyes with the vote for the checkpoints. We submit that this information, this specific pointed statement, from not merely a foot soldier on the ground, but the second in command, a very influential person in Lannister state hierarchy and the military, should have put General Baratheon on a course of further inquiry. And because of this, he has had the constructive knowledge as provided for in Roman 1 of the statute. We note further that General Baratheon took no steps in any case to address the commission of these crimes, and that the presidential decree in any case was not put out until the 31st of October 2014, and does not relieve him of his liability for failing to prevent the crimes at the time of their commission, as was held by the ICTY in Samanza at paragraph 407. For this reason, we submit that General Baratheon is criminally responsible for the acts of Lannister state forces on the ground. And that concludes the case for the prosecution.
Thank you very much,
Thank you,
Mr.
Your
Sanders.
May it please the Court. Your Excellencies, on the 12th of January 2014, the defendant, Jeffrey Baratheon, led a campaign in response to severe discrimination faced by the Lannister people. He sought equal rights for all religious groups in a state with a long-term history of religious persecution and violence against minorities. However, as the defendant's health declined, so did his involvement in this Lannister campaign. Throughout the remainder of the campaign, the defendant, Jeffrey Baratheon, relegated to a mere political figurehead of the Lannister state. With the defendant's reduced involvement, the campaign had been substantially misdirected away from its initial purpose. It is as a result of this that we are before this court today. Now, after hearing the prosecution's case, there are 4 key issues to be decided by this court. First, whether this court has jurisdiction to hear the present matter. Secondly, whether the defence bears criminal responsibility for the commission of sexual violence by Lannister forces. Thirdly, whether the destruction of the dam and agricultural sites offended the principle of proportionality. And finally, whether the defendant bears criminal responsibility for such acts. I will be making submissions concerning the first 2 issues before this court, and my learned co-counsel will be making submissions pertaining to the final 2 issues. We challenge the prosecution submission that international humanitarian law applies on 2 grounds. First, that an international armed conflict exists in the present matter. And secondly, if there is no international armed conflict, then a non-international armed conflict occurs in the present matter. This court must find in favour of both 2 grounds to find for the defence in this submission. Turning to the first ground, we note that the prosecution has relied upon the creation of a state for this court to find that an international armed conflict exists on the facts. Now, for this court to be satisfied that Lannister state constitutes a state recognised in the international community, it must satisfy the conditions under the Montevideo Convention. We submit that Lannister state fails 3 key conditions under the Montevideo Convention. First, that it fails to have a permanent population. Second, that it fails to have a defined territory. And third, that it fails to have the capacity to enter into international relations. Now, if this court finds that one of these key requirements is missing in this present matter, then Lannister state cannot be characterised as a state under international law. Now, we also note that the prosecution has not specified a specific date before this court as to when a purported Lannister state has come into existence. This is an important detail for this court, as it is difficult to ascertain when the prosecution contends the elements of the Montevideo Convention have been satisfied. In any event, the factual crux of our submission is that the Lannister forces were in the midst of their war effort and had not yet maintained definitive territory or a population. The facts are silent as to the numeric population controlled by the Lannister state. At paragraph 18 of the agreed facts, it states that, and I quote, "Thousands of civilians had fled the towns and villages surrounding Dawn." Additionally, at paragraph 26 of the agreed facts, it states that more than 100,000 people fled the city of Old Town. A reasonable inference can therefore be drawn that the population of the controlled territories was unstable throughout the duration of the conflict, It therefore fails to satisfy the requirements of a permanent population.
Are you saying that a permanent population must be a fixed number, or surely a permanent population changes all the time for any country? Isn't that correct?
Yes, Your Excellency. However, there must be some sense of stability as to the population, and indeed we see in the agreed facts that there is a substantial amount of citizens fleeing their place of residency during this conflict.
So in the case of Syria, for example, we've just heard there are 4 million refugees who have fled the country or are internally displaced. Does that mean Syria ceases at some point because there's so much instability to be a state because it doesn't have a permanent population?
Your Excellency, I'm unfamiliar with the particular characteristics of the conflict in Syria. However, Syria was declared a state prior to the conflict, and indeed this court must declare the Lannister state a state pursuant to the present facts before this court. I finally turn to the prosecution's submission that Lannister state had the capacity to enter into international relations pursuant to its recognition by the Iron Islands. If I may turn this court to page 5, paragraph 13 of the facts. It states that almost all states rejected recognition of a Lannister state. Therefore, the recognition by one state must be read in this broader context. A purported state isolated from its international community is incapable of entering into international relations. If this court finds that one of these criteria are absent in this present matter, then the prosecution fails in establishing statehood. In turning to the second ground, we challenge the prosecution submission that if this court were to find that Lannister state does not satisfy the criteria of statehood, that a non-international armed conflict exists in the present matter. We direct this court to submission 2 of our memorandum. As was required in the ICTY decision of Tadich and additional protocol 2 of the Geneva Conventions, a protracted armed violence must exist between the state of Westeros and Lannister forces. Now we note that the prosecution's timeline submitted before this court states that the conflict crystallized on the 30th of March 2014 and ceased on the 12th of January 2015. We return this court to paragraph 16 of the agreed facts, which leads up to the date of crystallization submitted by the prosecution. The ICTY decision in the case of Radonage listed relevant indicia for this court to consider, one being, in determining whether protracted armed violence exists, the sophistication of the military effort. Now, in paragraph 16 of the agreed facts, it states that 2 villages outside of Sunspear were looted and torched. This does not have the characteristics of a sophisticated military effort, but instead has the characteristics of mere banditry behaviour and terrorism. Subsequently, on the 30th of March 2014, it states that a small number of attacks were carried out by Lannister forces. The sporadic nature of the conflict in this present matter and the absence of a sophisticated military effort points to the fact that a protracted armed conflict does not exist in the present matter.
Agent, if it's not an armed conflict, how would you categorise what's going on here? I mean, I draw your attention to the fact that just a moment ago you brought our attention to the notion that there were many people fleeing, 100,000 people, and yet now you say this is not serious, it doesn't reach the gravity level to an armed conflict. So how would you categorise all of these circumstances? What is it?
We submit that it's mere banditry or terrorist behaviour.
And 100,000 people fleeing the city, it's still banditry.
If I may refer Your Excellency back to your example of Syria, in fact terrorism has occurred in that state, resulting in a substantial number of citizens fleeing. And still those circumstances do not rise to a protracted armed violence. In fact, it is quite a high threshold.
So you're beyond here, but you're suggesting that the Syrian conflict is not an armed conflict?
Not in the circumstances of that case, Your Excellency. However, the number of citizens fleeing the locations are a consideration for this court to weigh up. However, we submit that the sporadic nature of the violence should militate against the number of civilians fleeing.
Can I get some clarity here, if I may? So you're saying that we're actually below the additional protocol 2 threshold. So we're in some sort of state where it's a non-international conflict, but not sufficient to get to additional protocol. I lived through the negotiations on those 2 protocols. So I'm very sensitive to this issue and the ambiguities contained therein. But even so, all civilians, nonetheless, are still subject to protections under Common Article 3 of the 4 Geneva Conventions, are they not?
Yes, Your Excellency.
Even if banditry is still going on, you can still have violence against individuals, even if you haven't reached the threshold of additional protocol number 2.
Yes, Your Excellency. However, to my understanding, international humanitarian law will only apply where a protracted armed violence exists in the present matter. We submit that the present matter has not satisfied this threshold, and therefore international humanitarian law does not apply.
So you're saying this can't be a war crime? Could it be a crime against, obviously there's a lot to prove, but does that negate against the possibility of it being a crime against humanity under the terms of this statute?
No, Your Excellency. However, for this court's jurisdiction to be enlivened in applying international humanitarian law, this court must first be satisfied that these circumstances amount to protracted armed violence before any further consideration is made.
Thank you.
Alternatively, if this court were to find its jurisdiction enlivened in the present matter, we submit that the defendant does not bear criminal responsibility under Article 8 of this court statute, pursuant to the sexual violence committed by Lannister forces. Now, we do not contend the prosecution submission that sexual violence has occurred on the facts. What we do contend is whether the defendant bears responsibility for such acts. If I may turn this court to submission 5 of our memorandum.
On what basis do you make that submission, the previous submission?
Can I say clarification?
Upon what basis do you make the submission that your client does not bear responsibility for the sexual violence, having regard to the fact that you concede sexual violence took place?
Your Excellency, under Article 8 of this court statute, the defendant must have command responsibility over the Lannister forces that executed sexual violence against young women and girls. We submit that this does not exist on the facts, and I'll return to those reasons now. We contest the prosecution's case on 2 grounds. First, that the defendant lacked effective control over Lannister forces that committed sexual violence. And secondly, that the defendant took all necessary and reasonable measures within the ambit of his limited power.
So do you concede that he knew or should have known that these offences would happen?
We do concede that, Your Excellency.
Thank you.
If I may turn this court to submission 6 of our memorandum, we submit that General Baratheon's operative position over Lannister forces relegated to a mere political figurehead of the Lannister campaign. Commander Bolton assumed predominant control over Lannister forces at that time. Now, the ICC, in the decision of Bemba Gombo, found that the requirement of effective control is perceived as the material ability to prevent and punish the commission of crimes. Now, we know that the prosecution has relied upon the de jure title of the defendant as a general over the military forces. However, this case found that it is substantially insufficient for mere title to demonstrate a material ability to prevent and punish the commission of crimes. This notion does not extend to lower standards of control, such as the simple ability to exercise substantial influence. Now, we know that the prosecution's case in establishing effective control rests on 3 facts. First, that Commander Bolton was tasked with the duties of protecting the rights and values of Lannister people. Second, the meeting that occurred after the establishment of a checkpoint system. And finally, the presidential decree made by the defendant. Now, we note that the mere representation that the defendant delegated tasks to the commander to protect the rights and values of Lannister people does not explicitly or implicitly contemplate the commission of sexual violence by Lannister forces, and in any event is a mere press representation in pursuit of establishing a reputation of the Lannister state as a protector of Lannister people. Secondly, the meeting that occurred under paragraph 23 of the facts does not demonstrate that the meeting was held by the defendant, but merely that he attended the meeting. Additionally, it does state that Commander Bolton made an explicit mention of agreeing to the establishment of a checkpoint system, and that the defendant's reasons for agreeing to a checkpoint system were inaudible at the time. In any event, a checkpoint system had been established prior to the holding of the meeting, and if the defendant did provide an agreement to establish the checkpoint system, it was merely passive in this regard. Finally, we note that the prosecution relies upon the presidential decree by the defendant. However, the ICTY in the case of Blaskich at paragraph 485 found that a humanitarian order in and of itself does not establish material control. Additionally, I would turn this court to page 6, paragraph 18 of the agreed facts. It states that there was reason to believe that Commander Bolton was encouraging his troops to rape the civilian population. This should be read cumulatively with paragraph 19 of the facts, whereby following his television appearance, and I quote, daily attacks were carried out against the Andal and Dornish populations.
Counsel, could you also address the question I asked of the prosecution? What do you make of the fact that the accused congratulated Commander Bolton for various activities? Is that at all relevant here in terms of effective control?
Your Excellency, it is relevant insofar as establishing that the defendant is a mere political figurehead of the state. The characteristics of his congratulations merely related to the protection of the rights and values of Lannister people.
But the prosecution said that goes to the point that he therefore failed to take any action to punish those people. How do you react to that?
I note that my time has elapsed. May I have a brief extension of time to conclude this question?
How long do you see?
1 minute.
Yes, you may.
Thank you, Your Excellencies. We know I can answer Your Excellency's question on two grounds. First, that the statement that the press statement merely corroborates with his subsequent press statements, which establish a positive reputation for the Lannister state, that being that it's a protector of the rights and values of Lannister people. Secondly, what must first be established by this court is that the defendant has effective control over Lannister forces before this court determined what are reasonable and necessary measures to prevent and punish the commission of crimes. We submit that the defendant does not have effective control, and therefore he is unable to prevent and punish the commission of crimes in relation to the commission of sexual violence. Therefore, such a statement does not derogate from the limited ambit of his power. I would defer this court to our written submissions if there are further inquiries into the matter of command responsibility. If I can be of no further assistance to this court, that will conclude my submissions.
Thank you.
May it please the court.
May it please the court, I now address this court on the second count made under Article 5(2)(a)(2) of the statute, namely that the defendant launched an attack with knowledge that it would cause incidental loss of life, injury to civilians, damage to civilian objects, or environmental damage that would be disproportionate in relation to the concrete and direct military advantage anticipated. In defence of this count, I make two primary submissions. First, that the prosecution has not established that the LS launched a disproportionate attack. And second, in the alternative, that the prosecution has not established that the defendant should bear responsibility for any attack found to have been made. I direct Your Excellency's attention to the first of these. It is submitted that LS did not launch a disproportionate attack. To establish this submission, I address three key points. First, the scope of the count itself. Second, the relevant conduct comprising the attack. And third, the proportionality of the attack. Turning first to the scope of the prosecution's case. Under count 2, the defendant is charged with intentionally launching an attack in the knowledge that such an attack will cause incidental loss of life, damage to civilian objects, or environmental damage that would be clearly excessive in relation to the concrete and direct military advantage anticipated. This allegation concerns a breach of the principle of proportionality under international humanitarian law. However, the prosecution's written and oral pleadings appear to diverge from the wording of the count. They consider whether other additional crimes have been committed. Under count 2, submission 2A of their written pleadings, the prosecution state the looting of the convoy of relief supplies is an attack. Your Excellencies, the ICRC IHL commentary, which is a seminal text in the area, is organised as a series of rules. Rule 14 mirrors the breach alleged in the count concerning proportionality and attack. Rule 7 requires that attacks must only be directed towards military objectives. Rule 31 states that humanitarian relief personnel must be respected and protected. Rule 55 states that parties to a conflict must allow unimpeded access to relief supplies.
Council, the ICRC rules you refer to, do they represent customary international, or do you have evidence of that, or how should we take them? At what level should we look at these?
Your Excellency, it is submitted that these principles represent customary international law. I refer to Article 38(1) of the ICJ statute, which is said to represent customary international law in terms of the sources of international law. It is submitted that under this statute, or under this provision, the ICRC commentary would fall within first customary international law, but also a work of the most highly regarded publicist in the area. Your Excellencies, it is submitted that the only rule in this text which goes to the count is that of proportionality. The prosecution would only be able to bring a claim against the defendant for an attack on a relief convoy, which, contrary to the prosecution's submission, has a civilian character and is in fact especially protected under international humanitarian law, by bringing a charge against the defendant of intentionally launching an attack on a civilian object. Indeed, an attack launched on a civilian object is inherently unlawful. It requires no consideration of proportionality. Your Excellencies, as the defendant has only been charged with launching a disproportionate attack, it is this count to which the defence will confine itself if it pleases the court. Having defined the scope of the charge, it is necessary to determine which conduct the court should consider for the purposes of the attack. We concede that the bombing of West Rossi military positions in paragraphs 21 and 24 of the facts constitute attacks. However, we refute the relevance of the checkpoints on two bases. First, returning to the scope of the count. If the prosecution was seeking to establish the checkpoints as an attack on the civilian population, they would need to bring the charge under Article 52A1 of this court's statute, directing attacks against civilians. An attack against civilians should not be conflated with a legitimate, though disproportionate, attack. The prosecution have not sought to bring the checkpoints within this count, as they have not indicated how the checkpoints were directed at a military objective and how they were disproportionate. On another basis, we take issue with the characterisation of the checkpoints as an attack. And this concerns the definition of an attack under international humanitarian law. The ICTY in Struger stated that attacks are acts of violence against the adversary, whether in offence or in defence. According to the ICRC commentary again, an attack is understood as a combat action and refers to the use of armed force to carry out a military operation at the beginning or during the course of armed conflict. Additional Protocol 1, which is instructive, though we submit not applicable, as this we submit is at the highest a non-international armed conflict, defines attacks as acts of violence against the adversary, whether in offence or defence. We submit that the checkpoints do not meet this definition.
How do you respond to the submission of the prosecution that there was a threat and that is sufficient to fall within the rubric of this particular provision?
To clarify, Your Excellency, do you mean in terms of defining it as an attack?
Correct.
We submit that as attacks are acts of violence against the adversary or combat action or the use of armed force, a threat will not by itself fall within this definition. I also note that there has been some jurisprudence from the ICTY concerning whether or not mere mistreatment of the civilian population can constitute an attack. It is submitted that in the context of crimes against humanity, mistreatment may in fact constitute an attack. However, as this case concerns a war crime, it is submitted that the traditional definitions deriving from Struger, the ICRC commentary and the like should be applied.
So your submission is that an attack for the purposes of one crime is something different. from an attack for the purpose of another crime under the same statute. Is that the submission?
Yes, Your Excellency. I direct you to the fact that crimes against humanity are contained within Article 4, and crimes against, and war crimes rather, are contained within Article
But
5.
they both require attacks for the relevant purposes. But you're saying the meaning of what constitutes an attack is different, or can be different, under crimes against humanity as opposed to war crimes. Is that your submission?
We submit that the lesser threshold contained within the Vassal Yevnik case in the ICTY should apply in respect of the crimes with which that court was concerned. And that court was concerned with crimes against humanity. Turning to my final point for this submission. The attack launched by the LS against West Rossi military should not be taken to be disproportionate. I submit 3 reasons for this. First, the attack created an expectation of a legitimate military advantage. Second, it was expected that the advantage would make a relevant and proportional contribution to the campaign. And third, the damage itself has not been demonstrated by the prosecution to have been excessive. The prosecution has submitted that the military advantage actually obtained is relevant to proportionality. However, we submit that this analysis is prospective and concerns the anticipated advantage. Turning first to the legitimacy of the advantage anticipated. The prosecution has submitted that there was no perceived military advantage. State practice indicates that the security of the attacking forces constitutes a legitimate military advantage in determining whether or not an attack is proportionate. As there was also bombing launched by the West Rossi armed forces, it may be said that LS was responding to secure its own forces. Unlike in the case of Dragomir Milicevic, it cannot be said that the attack could only have been intended to cause civilian casualties. The prosecution has misconstrued our use of this case. We merely rely upon it to demonstrate the legitimacy of the attack, which we acknowledge is an element of proportionality.
But the mere fact that there might be a military advantage doesn't necessarily mean that this provision doesn't come into play. Surely, even if there's a military advantage, if the civilian damage is clearly excessive, then war crime has been committed, has it not?
That is correct, Your Excellency. We submit that this particular offence requires the prosecution to establish what the military advantage was, what the anticipated effects upon the civilian population would be, and whether or not the effects on the civilian population would outweigh the military advantage.
But aren't you doing yourself a disservice by saying outweigh? The words are clearly excessive, so what does that mean? And is that the same as the customary international law notion of proportionality, or is in fact this a more difficult threshold for the prosecution, or do you not have any submissions in that regard?
We submit that in stating that the damage must be clearly excessive, the prosecution bears a higher burden of proving that there was demonstrable or manifest damage that would be excessive. I turn now to an examination of why the envisaged harm was proportionate to the military advantage, or the envisaged military advantage rather, to be consistent with my previous submission. The prosecution has stated that the anticipated damage was disproportionate, pointing to the critical role of the dam. However, they have not engaged in the requisite factual analysis to persuade this court that, relative to the envisaged military advantage, the consequences of the attack would be excessive. For the prosecution to satisfactorily make out their case against the defendant, they must engage in this balancing exercise. Under international humanitarian law, the mere fact that an attack may be expected to cause even significant civilian casualties or damage to civilian objects will not render it by itself unlawful. According to Oppenheim, the presence of civilians will not render military objectives immune from attack for the mere reason that it is impossible to bombard them without causing injury to the non-combatants. There must be a balance maintained between the military advantage and injury to non-combatants. This principle was affirmed in Martich. While the defendant does not wish to proffer a particular number of casualties which would have made this attack disproportionate, and each case must be examined on its own facts, it is submitted that this court should apply the approach of the US Eastern States District Court in the Agent Orange case. There, the court held that the US military's use of extensive use of herbicides was not disproportionate. An argument that although the strategy was legitimate, it was used too often and too much was unsustainable. Your Excellencies, here the attack was crucial to the achievement of LS's military strategy. That it involved significant casualties and damage to civilian objects should not by itself render the attack unlawful, without the prosecution demonstrating that it was in fact manifestly excessive. I direct you now to Your Excellencies now to the second main submission concerning the defendant's responsibility for any disproportionate attack found to have been launched. The prosecution has submitted that the defendant was in control of the troops. However, they have not supplied sufficient facts to support this. We submit that the prosecution has also failed to state the correct test. To be liable, a commander must be in effective command and control of the specific forces engaging in the particular crime. In Kaishma at 231, the court confirmed that an ability to prevent and punish a crime is indicative of effective control. In Blastic, the tribunal found that the indicia of effective command and control are limited to showing that the accused had the power to prevent or punish or initiate measures leading to proceedings against the alleged perpetrators.
Counsel, in this case, one could suggest that whether or not he had the material ability to do so, he certainly believed he was still in command by issuing the decree. So the fact that, irrespective of not, he could actually influence the final acts, the fact that he didn't actually do anything to punish, is that not sufficient to constitute war?
Your Excellency, I answer your question in three parts. Before I do, I note that my time has expired. Might I have a minute to conclude? Thank you. First, I note that the presidential decree pertains to the sexual slavery. What we're interested in here is whether or not he had effective command and control over the forces engaged in the bombing. Second, the question of command and control is one of substance over form. The mere fact that the defendant believed he had control will be insufficient to vest him with that control in actuality. And third, to dispel any notion that the defendant had effective command and control over the troops engaging in the bombing, I draw your attention to the fact that the same meeting which took place at the time of the bombing concerns the checkpoints. The checkpoints had already been in existence before the defendant agreed to their use. This suggests that his accord was superfluous and that he in fact lacked effective command and control. If I can be of no further assistance to the court, that concludes my submissions.